election, and so thank you for being here. Let me remind you again that there will be audio recordings of the lecture today at the gazebo near the amphitheater and video discs, but they must be ordered and could be picked up later. Some of you have asked about a 13-minute DVD that we did of a conference we had here in June that deals with the future of Chautauqua as a place for all world religions. And it's in the bookstore, it's for $7. It's a 13-minute DVD that talks about looking at the future as we think and dream about a Chautauqua where people of every religion from the world feel welcome here. Today's representatives will once again be in front of the Hall of Missions. I'm looking for them. We still have places for you to sign up for this week's dialogue. This is a program that has taken place every Friday at 3:30. I probably will not get another opportunity to say thank you to the people who have made this dialogue series possible. It really grew out of the life of the community, and it has been an important effort that on Fridays every week we have had a dialogue opportunity for people to talk about what they've heard in the lectures. So with those people who are seated here who helped to make this possible stand is John Q. Barrett, Professor of Law at St. John's University in New York City, where he teaches constitutional law and legal history. John is also the Elizabeth S. Lene Fellow and a board member at the Robert Jackson Center in Jamestown. He is a renowned teacher, writer, public communicator, and has lectured here at Chautauqua during each of the past 11 seasons. He is a graduate of Georgetown University and Harvard Law School, and served as law clerk to U.S. Circuit Judge A. Leon Hickenbotham. Sorry about that, I even know this man. Higginbotham, thank you. It must be week 9. Professor Barrett is writing the biography of Justice Robert H. Jackson, who was a lifelong Chautauquan, Attorney General of the United States, a Justice of the U.S. Supreme Court, and Chief Prosecutor of Nazi war criminals at Nuremberg. He was one of the finest writers, judges, and leaders in U.S. history. And Professor Barrett discovered, edited, and introduced Justice Jackson's previously unknown, now acclaimed memoir, That Man, an insider portrait of Franklin D. Roosevelt. Professor Barrett's regular Jackson List emails, which I am privileged to receive, and you would want to if you began to receive them, pertain to Justice Jackson, to Nuremberg, the Supreme Court, and related topics. And they now reach, I'm told, John, well over 100,000 readers around the world. The title of his lecture for today will be Civil Rights and Judicial Appointments, Presidents Kennedy and Johnson and their successors. Let us say thank you once again to the Elizabeth Elser Doolittle Endowment Fund for Adult Programming for their support of this interfaith lecture series. And now, would you give a Chautauqua welcome to John Barrett.
Good afternoon, and thank you so much to Chautauqua Institution, the Department of Religion, my friend and teacher, Reverend Joan Brown Campbell, and Maureen Ravenio, and all of their colleagues who have made this possible. I have had the honor to speak regularly at Chautauqua on various platforms, under various auspices. Earlier this summer I taught in a special studies course, some 1045s, but I must say I actually think of this hall as my spot, and I'm glad to be back here with you. As an advertisement, let me note that following me and really ramping up from me at 4 p.m., Professor Pam Carlin of Stanford Law School will be speaking here, delivering the 8th Annual Robert Jackson Lecture on the Supreme Court. And so please, stretch and stroll a bit in between the two, but come back, because Pam is well worth your time. It'll be a wonderful lecture. I must say, with all of that history and connection to this place, I have never been an invitee of the Department of Religion. I am, of course, professionally and personally unqualified, deeply unqualified, to be a speaker on behalf of the Department of Religion, but their tolerance and Chautauqua spirit brings me here anyway. And I am deeply flattered. Religion, of course, is Chautauqua's origin, and it's still at the core of many of its high purposes. And we can define it in many ways, but at least as I think of it, religion is a capacious word. It's got a lot of space to encompass how we think about ourselves and others, how we make sense of why we're here, how we choose the paths on which we march and live our lives. I must say, Chautauqua, by that broad definition, is part of my religion. And so maybe at that level I'm qualified to be here. Another of my religions, if you will, is law, my profession, my teaching occupation. And that also is part of what I'll be talking about. Now, a little bit of a roadmap. I'm going to cover this in 6 parts. I'm going to speak briefly first about federal courts and the federal judicial appointment process, just to remind you a little civics refresher of what the general framework is of what we're talking about. And then speak briefly about presidential choices and criteria in the judicial appointment process. Then I'll turn substantively in part 3 to the judicial appointments in what I'll call the modern civil rights era. I may surprise you by where I begin that. Part 4 is going to be a bit about Judge Leon Higginbotham, who Joan already mentioned and who I look forward to talking about with you. Part 5 is going to be a bit about recent presidents after Kennedy and Johnson. And I'll conclude by taking you on a little bit of a journey with me, which I hope will wrap it up. Part 1, federal courts and the judicial appointments process. Article 3 of our Constitution, of course, creates a Supreme Court and such inferior courts as Congress shall by legislation create. And over the history of this country, through our various judiciary acts, we now have a 3-tier federal judiciary. We have our Supreme Court, which has oscillated, but for quite a while has been stable at a membership of 9. Below the Supreme Court, we have the U.S. Courts of Appeals, or the federal circuits, which number 100+ judges in multi-state areas across the country. And at the entry level, if you will, we have the federal trial courts, the federal district courts, which are many hundreds of judges. We also have other Article 3 specialty jurisdiction courts, and we have non-Article 3 federal judges, all of whom are appointed to their office by the President with the advice and consent of the Senate. In our historical practice, that has come to mean a nomination and then a senatorial vote requiring a majority for confirmation. But underneath all of that legal technicality and constitutional structure, if you will, is plain old politics. That's how we get our federal judges. We get an elected official who chooses for all kinds of purposes an individual for a vacancy and then tries to make the political sale to the Senate in the confirmation process. Now, part 2, how do presidents do that? Presidential choices and criteria for judicial appointment. Well, you lived through many, many decades of judicial appointments. I don't really have to tell you, but maybe to systematize it a little bit, let me flag these things. There are qualifications, there are assets, there are plus factors, and of course there are personal qualities that are at least non-disqualifying that I think are part of the package. Now what's in there? Well, legal background and ability as a qualification, of course. Personality, judicial temperament, fitness to be a neutral and arbiter, a decision maker. And let's add, in a modern word, diversity. Diversity in every sense, from geography and age to gender, ethnicity, race, religion, etc. And diversity as something that in the judicial realm, at least in the beginning, is always a question of what's not disqualifying. And then sometimes in the course of our history and our politics becomes something that is indeed desirable, that is qualifying, if you will. Now, we're focusing on presidents this week, and that's, of course, the triggering actor, the appointing actor, but this is a very shared process, this matter of judicial appointment. There is, in fact, senatorial selection at the back end by advice and consent, but really functionally as much on the front end. For the norms have developed over many, many decades of federal district courts really belonging to the senators who represent the state that contains the trial slot that is the vacancy. And presidents largely defer, subject to an American Bar Association or other screening process and a fairly deferential screening process by the executive branch, to the senator, particularly when the senator is of the president's party, for whom should be the appointees to these district court benches. Of course, we're talking the first level, if you will, hundreds of jobs, and subject to review. Now, above that level, in the courts of appeals, there's also a tradition, although it varies a little bit and it's diminished over time, of senatorial selection and control, with presidents largely, again, deferring on geographic political bases to who the senator wants for the vacancy on the circuit that is in his or her state, particularly a seat that is located in his or her seat. And generally, the higher you go, the higher the court, and to some extent, the newer the type of nominee, the less orthodox, the more untraditional the type of nominee, the greater the direct involvement and direct responsibility of the president for making the pick. Thus, of course, Supreme Court appointments are presidential picks. And judges of a different, fill in the blank, even at a circuit level and sometimes even at a district level, are matters of more and more presidential interest and involvement, at least until those become more usual. Now, in those spots, those presidential spots, high spots and in various ways lesser spots in the federal judiciary, this is for the president a realm of ethics, of values, of religion, at least of the civic constitutional variety. Our presidents exhibit themselves and demonstrate something about the values for which they stand and are governing in how they make these appointments. Thus, part 3. Judicial appointments in the modern civil rights era. I'm going to just proceed chronologically and cover a bunch of presidents, working my way, of course, to Kennedy and Johnson, and talk about how some of these selections reflect a bit of the time and the values, the ethics, the priorities, if you will, of various presidents. I'm referring to the civil rights era in a broad way. I'm back before the 1950s, before Martin Luther King, before Montgomery, before Brown. Because race, if you will, has pervaded our national experience, but has been a salient part of the judicial appointment process way, way back. And let me begin with Calvin Coolidge. You didn't see that coming, did you? In spring 1928, the final year of Silent Cal's presidency, he nominated Genevieve Rose Klein of Cleveland to be a judge of the U.S. Customs Court. Today, that's the U.S. Court of International Trade. She served from her confirmation in 1928 until her retirement in 1953. That, at her time, was not yet classified as an Article III court, but in a sort of retroactive sense, Congress legislated a declaration in 1956 that the Court of International Trade is an Article III court. And Judge Klein, by that service, by that Coolidge appointment, was the first female federal judge, Calvin Coolidge. Now, there's not much history about her. I've been surprised to find, and there are projects, if there's a student or a graduate student looking for a dissertation or a biographer, there's probably a real story in here. I don't know much more than that, but that is a pathbreaker of a type. And of course, what does gender mean in 1928? Well, it means something about a country where women can now vote, among other things. And so the value choice and that diversification and appointment of a type unlike all the predecessors, I think is a Coolidge political and value exemplar connecting to those realities. Next president, and I'm struggling to name all of them, some will be quite brief here, but we'll go through all following Coolidge. Herbert Hoover. What I'll note just in passing about Herbert Hoover and his one presidential term is that he had the experience of nominating and failing to obtain the confirmation of a Supreme Court nominee in 1930. And what was unique about that battle was for the first time, race was involved. Now, this was no African-American nominee to the U.S. Supreme Court. This was Judge John J. Parker, a judge of the U.S. Court of Appeals for the Fourth Circuit. But his body of judging in the Fourth Circuit included opinions that were controversial and criticized and a political campaign organized, joining the NAACP, concerned about racial dimensions of some of Judge Parker's decisions, and organized labor concerned with some of the anti-labor dimensions of his decisions, that coalesced to be a successful blocking faction politically. I must say that in hindsight, revisionists aren't quite sure that Judge Parker was done right by this defeat. And I'll note, as a side comment, he went on to serve for many more decades on the Fourth Circuit, and for 1 year was AWOL from that job to serve as the American alternate judge at the Nuremberg Tribunal, where Robert Jackson was the U.S. Chief Prosecutor. And what's an interesting contemporary indication of concerns that maybe Judge Parker was criticized a little too much or painted with too broad a brush was that every subsequent president up through Dwight Eisenhower, so from Hoover's defeat through Franklin Roosevelt, Truman, and Eisenhower, when faced with a Supreme Court vacancy and an appointment decision, had John Parker on the short list. Now, of course, he aged and he was never chosen, but I think that tells you something maybe about a revision and a reassessment. Franklin Roosevelt, well, we could be here for the rest of the afternoon, but let me note just something about sheer numbers. When you're president for 12 years, of course, and the federal bench by statute is growing during your presidency, you have a lot of appointment opportunity. And Franklin Roosevelt forevermore will be the president who most distinctly shaped the federal bench by the quantity and the qualities of appointees that he brought to the bench. For example, religion, since here we are. Catholics were not unprecedented, but more of them, distinctly more of them, were appointed throughout the federal judiciary by President Roosevelt, including Frank Murphy to the U.S. Supreme Court, former governor of Michigan, former Attorney General of the United States. Jews, again, not unprecedented, but in many more numbers at a much trickier time, came to be appointed to the Supreme Court by Franklin Roosevelt. Think, for instance, in just one little glimpse of this, of the message that's involved when Franklin Roosevelt in January of 1939 appoints the most prominent, prolific, voluble, civil libertarian, Sacco and Vanzetti defending, etc., Felix Frankfurter, America's top Jewish academic lawyer from the faculty of Harvard Law School, to the U.S. Supreme Court. Some of the press that emanated from Berlin in response to that was part of a darkening climate for the few Jews who were still in Germany and not aware that everything was going wrong and bad and they should be gone. But that's a choice. That's, not to put too fine a point on it, but that's a gesture, let's put it that way, from Franklin Roosevelt across the ocean at the start of 1939. Gender. There's not much progress, let's not overstate it, but a little bit. Judge Florence Allen is appointed by Franklin Roosevelt to the U.S. Court of Appeals. That's a real Article 3, no bones about it, no ambiguity, federal circuit appointment, and she serves for decades. Indeed, later Roosevelt and his Attorney General, Robert Jackson, had detailed discussions about potentially appointing her to the Supreme Court in the late 1930s. Now, that goes to Frankfurter, that goes to William O. Douglas. There is no breaking of the glass ceiling in this respect until decades later, but that's a part of what's going on. And of course, race. We haven't really talked about race yet. But in 1937, Franklin Roosevelt, in a peripheral location, cracks that ceiling. He appoints Judge William Henry Hasty to the United States District Court for the Virgin Islands. He is the first African-American federal judge. Of course, it is kind of offshore and out of sight. For Southern segregationist senators, that's, of course, the best place if you have to have one of that happening. And it is a statutorily term-defined position. It is not a lifetime appointment. But a path has started, if you will, under the Roosevelt administration. Now let's jump to Harry Truman. In 1945, he appoints Irvin Mollison to the U.S. Customs Court. That is the first appointment of an African American to a court with life tenure. Harry Truman also takes William Hasty of the district court slot in the Virgin Islands and makes him first the governor of the Virgin Islands, a presidential appointment in the late 1940s, and then a judge, life tenure, of the U.S. Court of Appeals for the Third Circuit, which includes Pennsylvania, Delaware, and New Jersey. This is a job in Philadelphia. So in terms of African American judicial path breaking, That's really the moment. William Hastie already was the guy, but that is the moment. Another Truman appointment that I want to flag, because he's a character I'm very fascinated with and write about, is Charles Fay, F-A-H-Y, a name that may dimly ring bells. Charles Fay had served on the National Labor Relations Board in the 1930s. He'd been Franklin Roosevelt's final Solicitor General of the United States during World War II. He was a brilliant, accomplished lawyer. He was a Catholic, the religion bar, if you will, at least for one Catholic seat on the Supreme Court and some representation below that in the federal courts, had fallen already. But Charles Fay, after serving as chief legal counsel in Berlin during the occupation, after being the legal advisor in the State Department the year after that, chairs President Truman's commission that recommends the desegregation of the United States Armed Forces. And among many things that Charles Fay embodied, with a white face, admittedly, was the future of equality in the realm of race relations. And Harry Truman puts him on the D.C. Circuit, where Judge Fay serves for 3 decades with great distinction, with, again, no real flack about any of that. But we're taking a step or two, maybe small steps, down further paths. Dwight Eisenhower. There are a number of things to note about him. In 1957, he appoints Scobell Richardson of Missouri as a second African American, serving concurrently on the U.S. Customs Court alongside Judge Mollison. In 1958, he appoints Judge Walter Gordon to be the third African American judge to, in effect, replace Hastie in the district court seat in the Virgin Islands. But I think what belongs here, as we're talking about ethics and diversity in judicial appointment, is the civil rights whites, I knew I wouldn't get that out smoothly, that Dwight Eisenhower appointed to the federal bench. And it doesn't get bigger or higher than Earl Warren as the Chief Justice of the United States. Now, to be fair, I didn't quite fully understand what he was biting off when he reluctantly delivered on his promise, a political promise to Governor Warren of California, that the first Supreme Court vacancy would be his. Fred Vincent drops dead. Warren says, we have a deal. Eisenhower and Herb Brownell, the Attorney General, said, well, that was about an associate justice. That wasn't about chief. And Warren says, first is first. Do we want to have this public debate? And Eisenhower recedes, and Earl Warren takes the bench in 1953, which of course becomes Brown versus Board of Education in May of 1954 and becomes the Warren Court through 1969. Earl Warren's second appointment, if you will, of a civil rights white, I did better that time, is William J. Brennan Jr. Again, turned out to be much more and different from what Eisenhower expected, I think. And he's appointed in October 1956 to get New Jersey Catholic voters to be positive about Eisenhower rather than Stevenson. But Justice Brennan becomes, of course, 30 plus years of service and a lion of civil rights on the Supreme Court. And below that top level, the Eisenhower appointees, particularly in the Fifth Circuit, the big, old, full Southern states Fifth Circuit, was the so-called Unlikely Heroes. If you don't know that book by Jack Bass, it's a story of the circuit judges, Unlikely Heroes, who really deliver on Brown in the civil rights litigation that is Mississippi, Alabama, Arkansas, Texas, all the way across to Florida during the 50s into the 1960s. And many of those judges, albeit all Caucasians, were Eisenhower appointees. Now that brings me to the heart of the lecture. Let's talk about President Kennedy. This week is proceeding chronologically, and so I'm technically abiding by the assignment, and we'll pause here in the centerpiece of the 1960s to talk about Kennedy and Johnson. And let's begin with Kennedy's words. This is in May of 1961. He's signing an omnibus judgeship bill, a statute creating many new federal judgeships. And this is how he describes his ethic, if you will, his decision-making process about how to exercise the presidential power of judicial appointment. I want for our courts individuals with respected professional skill, incorruptible character, firm judicial temperament, the rare inner quality to know how to temper justice with mercy, and the intellectual capacity to protect and illuminate the Constitution and our historic values. Now, in that last clause, do you see the sort of vagueness but yawning potential to deliver on our Constitution and our historic values? John Kennedy, in his brief presidency, appointed 2 Supreme Court justices, 21 circuit justices, and 102 federal district court judges. In all of that, which is a lot of appointing, a largely cooperative Senate during the 3 years, the 1,000 days, he appointed 10 Negro judges. The most famous, of course, is Thurgood Marshall, the Director Counsel of the NAACP, the winner of Brown versus Board of Education, the architect of the legal battle for civil rights, is appointed by Kennedy to the U.S. Court of Appeals for the Second Circuit in New York in 1961. And 9 others complete that roster of the 10 black judges. Wade McCree in Detroit, who's later elevated, we'll come back to that, to the Court of Appeals, and then became Solicitor General under President Carter, and if Carter had had a Supreme Court appointment, who knows, right? Is another of the black judges who begin their federal judicial service under Kennedy. Kennedy also appoints a Hispanic judge, Reynaldo Garza, to the district court bench in Texas, Brownsville, Texas. Judge Garza serves for many decades. But Kennedy is mostly frustrated, if you will, and mostly doesn't pick the fights, if you will, to push that number much farther. He does appoint a few others who languish in the Senate Judiciary Committee, chaired by Senator James O. Eastland of Mississippi, and in every way, think of the Philip song, Mississippi, find yourself another country to be part of. That's Jim Eastland's Mississippi. And Negro judges, to use Senator Eastland's parlance, was something that he didn't want very much of. They had worked out a dance, if you will. He gave some in return for some back. What he got directly for Thurgood Marshall, it appears, was the appointment of his Ole Miss college roommate, a fellow named Judge Harold Cox, to the Fifth Circuit. And Harold Cox is sort of the underbelly of unlikely heroes. You can read about Harold Cox in histories of the period. He's not only not bright enough, rest in peace, Judge Cox, and qualified enough, but he's a deep, believing Southern segregationist. And the Kennedy administration really tried. Bobby Kennedy interviewed him at the Justice Department with Byron White, the Deputy Attorney General, and Cox, Mr. Cox at the time, said, "I will abide by the Constitution." Well, of course, his idea of the Constitution and the Kennedy, if you will, the 14th Amendment, if you will, idea of the Constitution were in very different places. And Judge Cox becomes that kind of judge. But give Eastland Cox, and Eastland gives Kennedy Marshall. And maybe in the scheme of things, that's a good trade. Others just languish. Eastland's policy was basically, when he was back home in Mississippi serving constituents, the rest of his colleagues could pass 1 or 2 of these black nominees out of committee, but on a very slow basis. And that's why the total number is only 10. We'll come back to one who was in that language category, Leon Higginbotham. President Lyndon Johnson. Many more black judges, a longer presidency, and of course the presidency on the other side of the cataclysmic event, Kennedy's murder, in the South, which changed the political calculation, and then the 1964 election, the landslide, and the Johnson majorities that really become the death knell for James Eastland's world. He continues to serve and so forth, but stepping back and deferring much more. So Wade McCree is elevated from the district bench to the Sixth Circuit. Leon Higginbotham is appointed to the district bench in Philadelphia. Damon Keith in Detroit. Constance Baker Motley, one of Thurgood Marshall's colleagues in the NAACP, to the district bench in New York. Aubrey Robinson and Spotswood Robinson, each to the district bench in the District of Columbia. And soon Spotswood Robinson elevated to the DC Circuit. That's a lot, but not all of the African American judicial appointing under President Johnson. But more significant than all of that is a de-judging that precedes a re-judging, if you will, which is what he does for and with Thurgood Marshall and for and with us. In 1965, Thurgood Marshall is persuaded to give up life tenure on the Second Circuit, and Johnson nominates him to be Solicitor General of the United States. And it is a fight, and it is a fight that Johnson puts every muscle he's got behind, and he wins. And what's it about? Well, you know this story. Solicitor General is the government's advocate before the Supreme Court. It is the 10th justice in some parlance, if you will. It is a grooming spot, and anybody who's there is shortlisted to become a justice. And the Southern segregationists could see it coming. And sure enough, in 1967, it comes. LBJ literally creates the vacancy with a sort of a great political side move. He takes Ramsey Clark, an assistant attorney general, and makes him attorney general of the United States, which is a wonderful appointment perhaps in its own right, a bright, young, dedicated leader, kind of in the Bob Kennedy tradition. But he's the son of Justice Tom Clark. And of course, what LBJ is really doing is muscling Tom Clark into retirement. And that's the vacancy to which Thurgood Marshall is appointed, and again, after a fight, confirmed to in 1967. Lyndon Johnson appoints what probably, if the political stars had aligned differently, would have been the first female justice, Shirley Huffstetler, to the Ninth Circuit. He appoints civil rights judges, more civil rights whites in addition to these. Colin Seitz to the Third Circuit is one I will flag. Think about this, he's the Delaware Chancery Court judge who was affirmed in Brown versus Board of Education. All the other cases that are part of the Brown package are reversals, but the Delaware trial judge had struck down segregation. And bombing threats and evacuating his family and etc. followed. That's Colin Seitz, and LBJ made him a federal judge. Part 4, A. Leon Higginbotham Jr. What a mouthful of a name. Joan is only the 10,000th person, and I'm one of them too, who stumbled over that name. And his first name was Aloysius. And it's misspelled, because he was A. Leon Higginbotham Jr., the son of a menial laborer, an African-American man, himself the son of illiterate African-Americans in Trenton, New Jersey. And somewhere back, whoever named the first Aloysius spelled it wrong. And with great pride, because it was part of who he was and where he came from, Leon Higginbotham kept the spelling, kept the A, and made a point of telling this story, including to his law clerks early on. And I was one of them. I had the great privilege to work for this man for 2 years, right out of law school. These are fabulous jobs wasted on the young. And this is personal. Here's his background. Born 1928, Trenton, New Jersey. Public schools, tracked like all African-American kids into the Voc Tech menial course. His mother fights to get him into the academic courses, and somehow he does. And then somehow, through a boys' club mentor, he's encouraged to pursue engineering as a career. And he's told that there's an affordable, excellent university out in Indiana called Purdue. And he goes there to study engineering. And he's one of 12 African-American students, this is 1944, in an enormous Purdue student body, who aren't allowed to live in the dormitories. They are given the opportunity to rent space in what was called the International House, as if these students were not from our country. And that space was unheated attic with slat roofing. And when the winter came and the snow came in, and sleeping in 4 layers of clothing became intolerable, Leon Higginbotham at age 18, admittedly 6'5", but age 18, because he was a precocious early high school graduate, he somehow gets an appointment and marches into the office of the president of Purdue University and asks if they could have heated housing in some dormitory. Segregated. He's not even asking for integration, but heat. And the president of Purdue tells him, Higginbotham, you're lucky to be here. This country's at war. Take what you've been given and make something of yourself. And he left. He said, there are fights that you want to pick, and there are fights where you know you're not going to win. And so he transferred to Antioch College. He was one of 3 African Americans in that entering class. Another was, as he described her, and you know it, a gorgeous young woman named Coretta Scott. But she grew up to marry someone else. And Leon Higginbotham graduated from Antioch, and then he went to Yale Law School. And he was a brilliant, successful student, a great forensic advocate, moot court star, etc. And then he tried to practice law with his Yale law degree and interviewed with Philadelphia law firms. And as soon as he showed up and they saw he was black, there weren't opportunities. There was a black bar, and he went to work for the black leading law firm in Philadelphia, worked in the DA's office, became the president of the local chapter of the NAACP, very successful in court, etc., and an active Democrat. And in 1961, one of that team is now in the White House. Leon Higginbotham is a very young man. He's only 33 in 1961. But John Kennedy wants to make him a federal judge. Bob Kennedy, Nick Katzenbach, Byron White, they vet him. They scout this on the Hill, and the Eastland answer is no way. The pretext is age. He's so young, he's inexperienced, he's never served in public life. And so what the Kennedy administration does is appoints him to the Federal Trade Commission, where he's confirmed and he serves and he ages only slightly. In 1963, and you can really see the Kennedy presidency, sort of muscling up on civil rights. In 1963, damn it, they nominate him to the Eastern District Bench in Philadelphia. And he languishes in the Judiciary Committee. He said, I was just a dead piece of paper on Senator Eastland's desk, right next to the Civil Rights Act that President Kennedy was asking for too. Nothing was happening in the fall of '63. Kennedy tried to, sort of make a little public push. He took Higginbotham on Air Force One with a lot of newspaper photograph attention on a flight to Philadelphia on the Sunday of the week that concluded with Friday, November 22, 1963. But this confirmation never happens. In 1964, the different world, the Johnson world, immediately renominates Higginbotham, and he gets confirmed to the trial bench. In 1965, when Johnson has had his first Supreme Court appointment, Abe Fortas, and the prospect of more is going on, and he's ruminating with staff about a black appointee to the Supreme Court, the discussion is mostly about Thurgood Marshall. But thanks to Robert Dalek's great scholarship, we know that there was at least one conversation where Abe said, well, what about Leon Higginbotham? And I'm going to use President Johnson's vernacular, not his voice. I would not dare attempt that. But Johnson's response is, the only people who ever heard of Judge Higginbotham are you and his mama. When I appoint a nigger to the bench, I want everyone to know he's a nigger. Now that's rough. That's Texas talk, that's LBJ. It's a giant type that of course is all wrong now, but to kind of take it back and qualify it and understand it. Higginbotham stays on the trial bench, but becomes an LBJ advisor as the race problems of this country boil and boil, 66, 67, 68. This is one of a handful of people who the president summons and gets to know, and he gets to know the president. On the afternoon and evening of April 4, when King has been murdered in Memphis, Higginbotham is called in Germantown, where he lives in Philadelphia, and summoned to Washington the next morning, and spends the day around that conference table with the president, and spends the night as a guest of the Johnson family in the family quarters. And they're talking about race and what to do. In his oral history that's on the LBJ Library website, he remembers that the family and staying overnight in the White House, it's a big deal. And the dinner with the president and Lady Bird and the daughters. So it's nice to be here with Mrs. Robb on the grounds, because that was a moment where he was her family's guest. And what he is discussing with President Johnson is now, soon, for real, what can you do to make the lives of African Americans better? Not commissions, not proclamations, not talk, improvements. And he does real things, Higginbotham, and he does very real things, Johnson. Higginbotham brings Johnson to Philadelphia thereafter, and Johnson aids and takes him into deplorable substandard ghetto housing to show them what African American poverty living conditions are. Johnson appoints Higginbotham to the Violence Commission that follows the murder of Robert Kennedy in June of 1968. Johnson talks of appointing Higginbotham to the Third Circuit during Johnson's lame duck months in the end of 1968. Pennsylvania politics, Pittsburgh and Philadelphia, kind of take that over, and so that never comes to happen. Where does that leave somebody like Lyndon Johnson? Well, I can't do better than Judge Higginbotham's own words on Lyndon Johnson. I guess by that time I had become a great admirer of President Johnson's style and his capacity to get things done.
To be very honest with you, in 1960, it was inconceivable to me that I would have become a supporter of Lyndon Johnson. African-American, Northern, Yale, etc., Southern Texas Senator Lyndon Johnson. I was perhaps locked in with some of my old classmates at Yale and graduates of Yale who were fairly strong Kennedy supporters. I went to the Kennedy White House. It was a very classy thing. Then a few months later, my wife and I were at the Johnson White House. The first thing I noticed, it was so noticeable, was the long line of people waiting to shake hands with the president. This wasn't a quick Kennedy orchestrated clockwork formal classy event. This was a different kind of engagement. And it was interminably long, but you got to the front of the line and then you said to your wife, Mrs. X, I want you to know how grateful we are and the country is for all your husband's doing and all the abuse he's taking. He is the type of person who's going to help us turn things around. And she left absolutely radiant, Higginbotham said. When I watched his style and then watched the results, I became enamored and impressed and enthused because there's no doubt in my mind that in terms of improving the quality of life for people, he was much more effective than the Kennedys. On domestic issues, there's just no president, from my view, who has done as much in my lifetime to help the weak and the poor across the board. I don't know that Higginbotham ever actually heard the quote that Robert Dallek reproduces. It would have bounced off him in the scheme of things like nothing, because the substance is the presidency and the style and the values and the commitment. Now, when Carter became president, he elevates Higginbotham to the Third Circuit. The stars never aligned for a Supreme Court opening during the years when Higginbotham was of the right age, and so he served for many decades on the Third Circuit, including when I clerked for him, and then retired and was in private practice and teaching, and having burned the candle at both ends and many places in between, passed away when he was only 70, but left quite a mark. Certainly on me. Let me turn to the modern era, part 5, and tick through some presidents very quickly. President Nixon appoints the first Asian American judge, Judge Herbert Choi, from Hawaii to the Ninth Circuit. He contemplates, and I know John Dean is here on the grounds, who as White House counsel was involved in this, appointing the first woman to the Supreme Court. They had a candidate, Mildred Lilly, who did not measure up to the vetting process. President Ford, a brief presidency. In hindsight, we might say a sadly brief presidency. Continued judicial appointments in a progressive, high qualifications way with the incrementally improving diversity. But what he did was restore law to this country in very tangible ways. After Watergate and the Nixon resignation, making Ed Levy the Attorney General of the United States, appointing John Stevens to the U.S. Supreme Court, appointing William Coleman to the cabinet as the first African-American member of a president's cabinet, were pieces of the Ford legacy in this area. President Carter, in one term, had no Supreme Court appointment, had many circuit and trial appointments, and distinctly jumped all the numbers. Minority and female qualities were not only no longer disqualifying, they were desirable. That turn really happens during the Carter administration. President Reagan deserves mention because he pandered brutally and directly during the 1980 campaign, promising that his first Supreme Court appointment would be a woman. I'm probably sure he got some votes based on that. And I'm very impressed that he delivered. In 1981, against many advisors saying, well, that was just campaign talk, he finds, out in Arizona, in an intermediate appellate court, Judge Sandra O'Connor, who, of course, is a Chautauquan and a friend to all of us, and did great things during her judicial service. President Bush 41 deserves mention. Again, one term, a kind of continuity of appointments from the Reagan administration, but the retirement of Thurgood Marshall, the appointment of Clarence Thomas to succeed Thurgood Marshall. Murmur. Okay. We can talk about that later. But what was important and clearly, non-negotiable for President Bush was that we were not going to go back to an all-white Supreme Court. And I think that's an accomplishment. That says something about ethics and values. President Clinton took what Carter had done in one term and multiplied it across 2 terms. The sort of openness and diversity of women and minorities exploded under President Clinton. And President Bush 43 then, of course, was a switch to the other party. Ideology of a Republican conservative type became a defining important quality for the Bush appointees. But a couple of other things I think give you a glimpse into the man. I'm not talking about the administration, I'm talking about the man. I'm very convinced that he wanted to appoint the first Hispanic justice of the U.S. Supreme Court. That would have been Alberto Gonzales, who had been his counsel in Texas, who had been his appointee to the Texas Supreme Court, who became his White House counsel, who became Attorney General, and of course along the way became non-confirmable. And so President Bush never intended that. But among the things, of course, that he valued there was the Alberto Gonzales he knew, but I think also the diversity that that would have embodied. And, because it never gets mentioned, don't forget that George Bush tried to appoint a woman to the Supreme Court, Harriet Miers, which didn't work and was a personal selection of a confidant, but I think says something about gender not being disqualifying and maybe being an affirmative credential. President Obama's first term. I was trying. Some allege that there has been a slower pace of judicial appointments. And statistically that bears out a little bit, but not as much as you might think. There is less ideology, certainly of the Bush type, but of the anti-Bush type, there is less ideology characterizing the Obama appointees. He has not gone hard left. He has not picked the progressive luminaries of legal academia for judicial appointments, for instance. He has sought and appointed excellence and accomplished a lot of it. Also, in the particulars and in the systemic impact, don't forget that in the first 2 years, he got 2 Supreme Court appointments, which are oxygen-consuming events for a White House and an administration and the Senate process and so forth. And out of that, maybe the lower court appointments lagged a little bit. And on the other side, we have Justice Sotomayor and Justice Kagan. A first Hispanic justice, a third concurrent female justice. I think we will never go below 3 on the court, and I think we'll soon have 5. And then it will oscillate as it should on gender, 5'4", 4'5", maybe every once in a while 6'3", female, but never 6'3" again, male. We're pausing at that moment now, but I think we're going to leave it in the past. And Obama, my crystal ball isn't anything special, so we'll see. Obama has also done quite a bit for women and minorities beyond those categories. Judge Lorna Schofield, for instance, nominated and pending to the trial court in New York, would be the first Filipino-American judge. She's out of committee and will probably get a vote in a kind of package deal when the Senate returns from its recess on September 10th. Now notice what I've not mentioned, homosexuals. Let me try out a joke on you. It might work better here. I tried this once on my students just to see if they were paying attention. You, of course, all know that homosexuality was invented outside of Menlo Park, New Jersey in the 19th century. It has a little Edison thing that maybe works here. This is nothing new, right? Homosexuality, gay men, lesbians, diversity. Examine your life, your loved ones, your family, your friends, your worlds. And none of that was invented in Menlo Park or anyplace else anytime recently. Obama's appointments include the following. July 2011, Judge J. Paul Etkin to the federal trial bench in New York, the first openly gay man appointed to the federal bench. October 2011, Allison Nathan, same court, lesbian appointee. March 2012, Michael Fitzgerald to the U.S. District Court for the Central District of California. A long wait for a vote, but in the end, like Etkin, like Nathan, confirmed, and the votes of Etkin and Fitzgerald are similar, about 91-6. We have 6 who vote no. They don't explain why, they just vote no. Pamela Chen, a pending nominee to the Eastern District, is a lesbian and would be the second female Chinese-American federal judge ever appointed if she's confirmed. But, November 2011, note also the withdrawal of Edmund Dumont, nominated to the U.S. Court of Appeals for the Federal Circuit. A circuit judge, but a specialty jurisdiction court. He'd been pending for 18 months, and the Senate was never going to act on this nomination. And Mr. Dumont, practice, a life, a family, needed to get out of the limbo, and he withdrew. He would have been, we have never had yet, the first openly gay federal appellate judge. Note a pattern which echoes the race pattern that I've been chronicling. North and West, New York and California, 1 and 2, and a smidgen of progress. Lower courts before appellate courts. So where does this leave us? Well, in conclusion, I want to do two things. Here's my theoretical thought. We are, in all of our variety, human brothers and sisters. Now, I recognize fully that for some, homosexuality, particularly homosexual conduct, is a matter of religious belief. But frankly, everything is, or has been. And I would modestly, gently suggest that no religion is static, and that religious discourse and development is a reality that reflects our fuller knowledge, our real living, our personal knowledge and relationships, our deep reflection, and over time, our betterment. I'm not here equating race and homosexuality. Maybe they are exactly the same, maybe they are different things. That's a matter of study, of science, of disciplines that I can't represent. But I'm also not equating homosexuality with vegetarianism or with a football fan's rooting loyalty for the Green Bay Packers. I am equating humanity with humanity. And I'm reminding all of us, myself included, that our faiths, our personal relations, and our legal systems are founded on commitments. Deep, defining commitments to human equality. It's a point where we converge. It's something that we all share. And we're at our bests, including our leaders, leading us to betterment, when we and they live up to that ethic, to that faith. Indeed, it's a heavy word, but to the love that is equality. And so let me take you on a little bit of a closing journey. One place to physically see the progress that I'm talking about is Arlington National Cemetery. And I had the chance to be there on Saturday, which was a day like this, just glittering gorgeous. And I've been working on this lecture. I didn't quite have my closing piece, and then I stumbled on it. Arlington, Northern Virginia, once belonged to Lord Fairfax. Of course, that didn't work out. And then it came to belong to Virginians. It belonged to the Custis family. It was a large plantation. Martha Washington's first husband was Daniel Parke Custis. Her great-granddaughter, Mary Anna Randolph Custis, married Robert E. Lee. They had vast wealth and property. And part of their property, part of their 18th and 19th century property, was human beings. It was a slave plantation. And appropriately, the slave quarters are preserved on the highest point behind the flag, on the backside of the hill, if you will, in Arlington National Cemetery. Now here's what I want you to visualize. Many of you have been there. As you walk up into the cemetery and approach the grave of John F. Kennedy in the eternal flame, the Custis Lee Mansion is above you on the hill, the towering mansion. To your right, on a knoll, a little below and to the side of Kennedy, is what has become a Supreme Court corner. Oliver Wendell Holmes, a justice appointed by Theodore Roosevelt, died in 1935 and was the first justice to be buried there. He was a Civil War veteran, thrice wounded in the Civil War. William O. Douglas, a Roosevelt appointee who died in 1980, was an ROTC cadet who never got out of Whitman College parade grounds in 1918 in terms of military service, but he's buried there. Potter Stewart, Justice Stewart, who died in 1985, served in the Navy during World War II. He's buried there. Chief Justice Warren Burger is buried there. He died in 1995. Justice William Brennan, who died in 1997, is there. He was a colonel in the U.S. Army during World War II. Justice Harry Blackmun, who died in 1999, who employed Paul Etkin, Judge Etkin of the Southern District, and Pamela Karlan, as among two of his glittering roster of law clerks, is buried there. Martin David Ginsburg, who died in 2010, is buried there. You might say, wait a second, that guy wasn't on the Supreme Court. And you're right. His stone reads that he was a caring citizen, advocate, teacher, and family man. His stone has a Star of David. His stone has a Hebrew prayer. And then it says that about his life. And then there's a lot of blank space underneath it for his family life and his devotion. And part of his accomplishment as part of an incredible team is the flourishing career of Justice Ruth Bader Ginsburg. And there's one more stone. Thurgood Marshall, who died in 1993, is buried there. They're all neighbors for eternity. And that's kind of ironic in some ways, but I digress. Thurgood Marshall was not a military soldier. The front of his stone says Associate Justice, 1967 to 1991. And as you look at the front of his stone, over it, in the background, is the Custis Lee Mansion. Walk around to the other side of the stone. When you turn your back on the Custis Lee Mansion, when you look down over the Potomac River, when you gaze on the Lincoln Memorial, the Washington Monument, the nation's capital, our country, our people, drop your gaze just a little bit, and right in front of you on the back of Thurgood Marshall's stone, the obverse is this simple epitaph: Civil Rights Advocate. For all of us, I think that is a very hopeful, progressive tableau, and it is the religious, ethical, human point of it all. Thank you very much.
You know how to do the questions by now? I can see well you do. We'll go from side to side.